They have a regulation that says we have to keep documents for a minimum of 3 years. And those documents include 3 parts. There's 3 parts of what you're required to keep. Part number 1 is all contract documents. That means rejected contracts too. Okay? So all contract documents, all disclosure-related documents, and here's the kicker. All documents reasonably related to a transaction. That includes emails. Okay? Those of you who are on SkySlope, you can actually copy into SkySlope and all your emails will automatically be downloaded, right? Which is awesome. It'll make it super easy for you. But the emails belong in there, and I'll tell you something, every time we get a Bureau of Real Estate inquiry and they say, send in the file, and it may not be you that's investigated, it might be the agent on the other side, it might be a related agent, it may not have anything to do with us. But when I get the file and I look through it and there's no emails, I won't even send the file to the Bureau because they have a meltdown. And we've had one agent that was fined for not having emails in the files. So they have to be in there. Now, one other thing. This is agent law. There was a law that was passed in January that Governor Brown signed, and it said you don't have to keep text in the files. Okay, that's not exactly accurate. What the law actually says, and I'm going to give it to you in a little bit more simplistic language, because I don't even understand the law. I mean, it's crazy the way it's written, but this is essentially what it means. If you have text between you and your clients that mean nothing to the file, like, I'm running 5 minutes late, I'll see you in a minute, you know, it's hot outside, something like that. Who cares? Those don't have to be in the file. But if it's anything related to the transaction, it does have to be in the file. So let me give you an example. I looked at a file not too long ago where a buyer texted an agent, I just found mold at the property. You think that ought to go in the file?
Yes.
Yes, that should go in the file. Now, the other day, well, actually last year, we were in Bev and I were in mediation. And we successfully convinced, we were the listing agent, and we had 2 agents that were a partnership. And we successfully convinced the mediator, the buyers, and the sellers that we had no liability. This was an investor resale, by the way. That we had no knowledge of any of the conditions, had nothing to do with it, and therefore we shouldn't pay a dime in the case. Well, we were so good at convincing them that the buyer sued the seller, but did not sue us. And the seller didn't sue us. But I got a subpoena the other day for all of our records, okay? So I put together all the records and all the emails. So I'm going through the emails, and yikes. Some of the emails were between the 2 partner agents, and one of them started with, my seller is such a dummy, he's not going to understand what to do with this.
Oh.
He is so stupid, he's not going to know how to disclose this. Yeah. And I've done my best to keep out what I can arguably call irrelevant. But some of them I legally and ethically have to produce. I have no choice. And I'm reading this and I'm thinking, okay, really? I want you to be really careful. I want you to think before you hit send, especially if you're angry. Okay? Don't talk badly about your clients. Don't talk badly about other agents, because those emails could wind up in my lap, and could wind up in your client's lap, and could wind up in opposing counsel's lap, okay? And I'm keeping my fingers crossed that these emails didn't incite anybody.
Isn't it also true that whatever you're texting to the escrow officer or emailing and the lender can also be subpoenaed?
Of course. So the question was, can anything that you're emailing or texting to the escrow officer or the lender? Okay, let me tell you something. When I get these cases in, and you guys have been sued, the first thing I do is I issue subpoenas to the lenders and to the escrow company, and I ask for their complete files, and it is amazing what I get. Yeah. So whoever you're dealing with, you have a public image, you want to make sure that you portray that. Okay. I'm going way over, so I'm going to talk super fast. Contract, what I'm going to do. All right, multiple counteroffers. When you are issuing multiple counteroffers, do not mark the box multiple counteroffers unless you are actually issuing multiple counteroffers, okay? So, because otherwise it's misleading to a buyer. If a buyer gets back from the seller a counteroffer and the box is marked multiple counteroffers and there are no multiple counteroffers, isn't that a little misleading? Okay, so I want you to be accurate and I want you to be careful on that. If you issue, and this seems to be coming up a lot, if you issue a counteroffer and you're representing a seller, and then a better offer comes in, you need to revoke that counteroffer before accepting the other one, okay? How do you revoke it? You do it in writing, and this is what I would do. By the way, the law says you can actually do it verbally, but that's not advisable. What I would do is call the agent where you sent the counteroffer and say, my client's revoking it, document that, and then immediately send it, okay? Or send it and then call, but do both. So we don't have these issues. Okay. I'm actually getting phone calls. I can't believe this. Sales conditioned upon the buyer sale of their home. I haven't seen this since like the 1990s, believe it or not. So this is kind of interesting. Have you guys had these offers? Yeah, I couldn't believe it. Okay, so I get a call from an agent the other day and wasn't quite sure because she said, when do the inspection periods start running? Because we haven't done these offers in so long. Okay, so here's the answer. Upon acceptance of the contract. Unless you draft it otherwise, it's upon acceptance of the contract, not removal of the contingency relating to the sale of the house. The reason the contract is designed this way is so that the buyers have skin in the game. Okay? If you are representing a buyer and you want it otherwise, then you need to edit the contract so that the contingencies, all the contingencies don't start running until removal of that contingency as opposed to acceptance. Okay? All right. Pass-through and non-refundable deposits. No drafting pass-through deposits unless you have run it by your manager. Okay? I'm giving the managers a lot of work. I'm sorry, guys. Okay? This is really, really, really dangerous. Now, if you look at paragraph 11A, liquidated damages, there is a new provision. And it basically says that if it is contrary to the law, it's illegal and unenforceable. My words, not theirs. When you read it, it's like, who the hell knows what they're trying to say? But what I'm telling you is that there is actually case law out there that if you draft a contract with a non-refundable deposit based on the terms of the contract, it is illegal and that deposit will be refundable. The only way we can do this is to create separate consideration. So let me give you an example of, I've worked with your managers to create separate consideration. For example, we have extended the close of escrow and have passed through a deposit in consideration for that so that it becomes non-refundable, okay? We created one where it was brand new construction and so the money was used for upgrades and additional construction supplies, and so we created that. Now it is not 100% solid, but we were able to create that. These are very, very dangerous transactions, and so I want you to be really careful. Here's the problem. Let's say that the seller says, give me $10,000, I want the deposit passed through to me, $10,000. The buyer says, the buyer really wants the house, so says, okay, fine. Then the buyer does their inspections and doesn't like the house and wants to cancel. Then the buyer says, give me back my deposit. Well, the seller has probably already spent it. And then the seller says, well, I don't have it to give back to you. And the seller says to the agent, well, you told me this was non-refundable and I didn't have to give this back. Who's going to be left holding the bag? We are. Okay, so be careful. Okay, non-assignability. The new RPA now has paragraph 26 that I want you guys to be aware of. These contracts are no longer assignable unless you have the seller's written permission. Okay, so let me back up. Historically, it is the law in the state of California that every contract, unless it's a personal service contract, cannot be assigned, or can be assigned, unless the contract says otherwise. So, like, your listing agreements can't be assigned, unless it's to another agent by the broker. But you can't go give one of your listing agreements and assign it to Keller Williams, right? And I can't assign my retainer agreements. But purchase and sale agreements for properties can be assigned until now. Now CAR has added paragraph 26, which says the contract cannot be assigned without the seller's written permission not to be unreasonably withheld. I'm telling you, it's giving great latitude to these sellers. So let's say you have a situation where, and this is where I think it's going to be a problem. Number one, you have somebody who's buying it and wants to either flip it or transfer it to their LLC, or transfer it to their investors. If you have a transaction like that where you know that your buyer wants to transfer it, take out paragraph 26. So in the other, put paragraph 26 is deleted. Okay, so it gives them that ability. Don't write at the top of the page, buyer or assignee. Or I saw the other day, nominee. I don't know what a nominee is. That is not going to be sufficient. You have to take out paragraph 26. Now here's where I think you guys are really going to struggle with this, that I want you to think ahead on. How many times have we had a transaction, especially in today's market where lending restrictions are really tight and it's hard to get a loan, where the buyer says, I can't get my loan, so I want to add my brother, or I want to add my mom, or my grandmother, or my uncle to the contract. And it used to be that agents would call me and say, the seller's really difficult and won't let me add it. And I'd say, it doesn't matter, the contract's assignable. Assign it to them. Okay, I can't say that anymore. And if the seller has a backup offer for $25,000 more, do you think they're going to cooperate with you? No. So that means that when you're writing offers for buyers, you need to do your homework, okay? And if this is an issue, add them all right now, or delete paragraph 26, so that you don't have this struggle right before the close of escrow.
Can you go the other direction and take somebody off?
You can probably take somebody off, but here's what you're gonna, here's the problem. Here's gonna be the rub. On paragraph 2 of the RPA, it basically says that the buyer is making representations about their financing and the ability to purchase. The seller is accepting what the buyer has represented, and if the buyer changes that, then it's contrary to the contract and the seller doesn't have to cooperate with that. So, you know, if mom and dad are on there and then dad decides to drop off and doesn't take title to the property but drops off of the contract, you might have a little bit of a problem if the buyer can't qualify because the seller doesn't have to cooperate. It's like changing financing terms. You know, you can't go from an 80-20 down to a 90-10. The seller doesn't have to cooperate with you. Okay? Okay, let's talk for just a second about the Bureau of Real Estate. What if a Bureau of Real Estate investigator calls? What do you do?
Call them.
Tell them to call Bev.
Do not take the call. Take the number and pass it to your manager. Do not talk to them. Okay? They can be very nice, particularly when they want something, but this is what Bev and I have figured out with the Bureau of Real Estate. When they are calling you, it's because they've gotten a complaint.
Really bad.
And the buyer, or whoever the complaint is, maybe it's one of your competitors, that's happened, has gotten in the Bureau of Real Estate and told them their story. So they're approaching this with a set of information thinking you did something wrong. And I can't tell you how many times I have gotten these calls or these letters where Bev and I have written back and explained what you did and how right you were, and it's gone away. I actually had one of your buyers complaining that you never offered a home inspection. Absolutely false. The file showed that you had offered a home inspection and they in writing declined it. Okay, did that go away? Yes. But the investigator called accusing us of not making, a home inspection and not offering that or not even suggesting that to the buyer. In that situation, by the way, the buyer also said they were a first-time home buyer, and I was able to show that this was house number 4. Okay, but they're going to get you on the phone, and they're going to schmooze you into saying things that you don't really want to say, or that could be not very helpful to you. So please don't take those calls. The minute you get one of those calls, you say, I need to discuss this with the manager, I'll call you back. Get the name, phone number, and talk to your manager about it, and we'll help you with that. Okay, that's what we're here for. Okay.
Do you want to talk about the increase in?
Oh, I should have put those statistics in there.
Just briefly.
Oh, darn.
Okay.
I should have put, I have some statistics I was sharing with Bev about the increase in claims. I should have sent those up to you, that I had gotten directly from the Bureau of Real Estate. And I think it was it was a dramatic, I think 31% of all claims turned out to be a major issue with licensing violations found. There is virtually double complaints and investigations this year over last year. Shoot, I should have
It's
done
okay,
this.
you can send that to me.
I'll send them
I'll
to
get
you,
it out.
because you guys will be fascinated with this. I'll send these up, because you'll be fascinated with. By the way, the number of agents has declined by 100,000 agents from 1997 to the current. Mhm. Yeah, so through this market, 2007, I'm sorry, to the current, so through this market. But the Calvary claims have dramatically skyrocketed, and I'll get those statistics, because you guys will be really interested in this. Okay, new statutes. Truth in lending laws, have you guys heard about this? It's changing as of August 1?
Yeah.
Okay, so the forms are changing. Instead of 2 forms, it's now merged into 1. Quite frankly, I don't really think it's going to affect us much. It's going to affect the mortgage brokers and it's going to affect the lenders. It does extend the time frame. You guys need to be aware of this. It extends the time frame from 3-day right of rescission, where it currently is, to 6 days. Now, I've talked to the lenders, and they think they can shrink it down to 4 days by using electronic signatures and doing it electronically. But you need to know that there needs to be some flexibility, and when you're writing offers, it could take a little bit longer to get financing. So you just need to be aware of that don't put things, if your buyer's getting a loan, don't put it on a 15-day contingency, or 15-day escrow, because there's no way you're going to get the loan processed by then.
One of the other things too is, Shannon, the occasional last-minute scramble to have the seller pay for something.
Yeah.
The HUD is now a pre-funding requirement, or will be a pre-funding requirement, not a pre-closing requirement.
Yeah,
So
did you guys hear that? The HUD is now, it has to be an accurate HUD. So, now we get all these drafts of the HUD, and the final doesn't get produced until 2 or 3 days after the close of escrow, and you guys are constantly making changes and credits going back and forth. They're going to require it up front as pre-funding.
And then isn't it 3 days from the time you send signature to release?
Yes.
So people need to figure that in.
Yeah. Okay. Agency disclosure is now required in commercial transactions. So anybody that's doing commercial transactions, what is the penalty for not doing an agency disclosure? Does anybody know? Loss of license? No. Anybody else? Loss of your commission. That's the penalty. Can you imagine working that hard and not doing your agency disclosure and then jeopardizing your commission? Oh my God, I can't think of anything worse over one piece of paper.
Wow.
So make sure that you do your agency disclosure, and now you've got to do it if you're doing commercial transactions. Okay? Now what's interesting is the statute hasn't addressed 5 units or more. There's 1 to 4 units in commercial transactions. I would do an agency disclosure, period, just to be on the safe side, okay? All right. Any final questions? Yeah.
Okay, when you have a request for repair, and then the seller has the seller's response, now if they're giving a credit back, doesn't it give them the protection in section C, I think it is?
It's protection only for those items and what's known.
So make sure.
So what happens if there's further issues found later? It's not going to protect them for that. Yeah.
Same thing regarding the request for repair, when the seller say, I do provide you $5,000 credit. Now, we obviously know that when the lenders see all this information, they want to know what's there for $5,000. And sometimes we draft up many addendums to say just a $5,000 credit and kind of not giving them the exact list of items to repair. How do you see that problem? Are we concealing this from the lender?
Well, yeah, you are concealing it from the lender. I mean, technically, if you write $5,000 credit and you don't say what it's for, it's just, you negotiated that on behalf of your buyer or the seller is, and you don't want to list out what it's for, is that concealing it from the lender? Yes. Is it done all the time? Yes. Is it something I'm encouraging you to do? No. Here's another issue, though, that I'm a little concerned about. I can't tell you how many times a buyer comes back and says, I sues for roof problem. And the agent says, well, that's what they got the $5,000 for. But the $5,000 says nothing about the roof problem. There's no connection between the $5,000 payment and the roof problem. So the buyer will say, no, you just gave me $5,000 because we're closing escrow and, that was just part of the deal. It wasn't connected with the roof deal. And unless you've got some sort of proof somewhere along the lines and a connection, you're not getting, like what she said, that there is a release in the request for repairs, that if you get compensation, there is a release. It's not a huge release, somewhat limited, but at least there's a connection there. So just something to think about. Yeah.
Quite a few lenders encourage you not to identify that. They encourage you.
Oh.
They encourage you to write it $10,000 toward repairs versus saying toward roof repairs.
Okay, so great question. Some lenders encourage you to write a credit versus connecting with the repairs. It's not the lenders, it's your mortgage broker, it's not the lenders, because I promise you, if you call Wells Fargo directly and say, put that in writing, they will never put it in writing. You need to keep that in mind, because mortgage brokers, and I'm not saying anything about mortgage brokers, but they lead us down these paths all the time and say, it's okay to do this, it's okay, it's okay. And then where are they when the you-know-what hits the fan? So really just keep that in mind, it's not the lenders. Awesome, thank you.
Thank you all for being here. Shannon is just one of the many resources you have available to you, including me and your manager and regional managers to help keep you safe. Thanks for being here today. I really appreciate it.
Thank you for having us.
Thank you.